Adeyemi, my humble appearance to the claimant, my lord.
Okay. Yes, go ahead.
Respectfully, my lord, Nosa Karik. Appearing with me
Yes.
is Omolola for the defendant.
Omolala Ajibola, you said?
Yes, my lord. Omolola Ajibola.
Okay, good.
Yes, my lord.
Ajibola, okay. That's good. Okay.
Thank you, man.
So where are we?
My lord, the matter is slated for report of settlement. However, I'm here to report that parties are still exploring settlement. And in light of this, we'll be asking for a further date to report him.
Mr. Garrick?
Yes, my lord, I confirm that we're still exploring settlement. But just as hinted by the court at the last adjourned date for the defendant to settle all outstanding. Just want to put it on record that we've complied with that, and all of the outstanding have been settled. Parties are just discussing as it relates to other matters that the court had rightly said that within the jurisdiction, the discretion of the honorable court. So we're looking to see how we can resolve that aspect. But as per the core matter, those have been settled as of today.
Mr. Adeyemi, is that correct?
Yes, my lord, I confirm. Yes, my lord, I can confirm saying that all the outstanding have been settled. However, parties are still exploring settlement as regards the other reliefs in the processes, my lord.
Oh, okay. So, counsel, you need to work harder so you can resolve the other reliefs. If they made the outstanding entitlement, which is the core of the matter, they have been resolved, then you should work a little bit harder so you can settle the rest.
Yes, my lord.
Okay, then. I wish you luck.
Thank you, my lord.
So, in the circumstance, Registrar, can you give us a date?
Yes, my lord. 21st October. 21 October, my lord. 21st.
Okay. Is it convenient to cancel?
Can you do the 20th? My lord, I'll just wait for counsel to confirm.
Can we get an earlier date? Or you get a date?
What would be the date convenient for the court to just be resuming back from vacation?
Can we get maybe 26th or 27th October?
No, I'm out of town there. I'm out of jurisdiction. 21.
Registrar, 20, the last week of October is not convenient for the court.
Yes, my lord.
Okay.
Keep
29th, you still out of jurisdiction.
I'm not back till December.
Okay, let's do that. I'll have to come then. 21st is convenient.
2-1 October? Is that what you say?
Yes, my lord.
2-1 October.
Yes, my lord.
Okay, so case adjourned to 2-1 October 2026 for report of settlement.
As the court pleases.
As the court pleases.
Okay. So you can leave the meeting. Registrar.
Yes, my lord.
Okay, which other matter?
NICN/LA/12M/2025 between Mr. Opav James and Okura and CCL Robber.
Respectfully, my lord, R.O. Nwazufu for the judgment debtor, my lord.
Can you spell the name?
R.O. Nwazufu is spelled N-W-A-Z-U-F-U, my lord.
Okay. Now you are for the
Thank you, my lord. The judgment debtor, my
debtor?
lord.
Okay.
/ applicant, my lord. Yes, my lord.
Okay. The judgment creditor here.
Yes, my lord is aware
No,
of the
my lord.
cheating. Please join.
Has he joined? Has he joined the meeting? Did you send hearing notice to him? Did you send the Zoom details to him?
Yes, my lord.
And you call him and confirm you received the Zoom details, because if he doesn't have the Zoom details, then he cannot join the meeting. Call and confirm he has received the Zoom details.
My lord is already joining. Okay, it's fine.
Yes, registrar. Registrar, what did you find out?
About to join the meeting.
My Lord,
Pardon?
J.A. Ugisi. Yes, my Lord, J.A. Ugisi. I appear for the claimant. J.A. Ugisi, my Lord, I appear for the claimant. Judgment creditor. The judgment creditor.
Okay.
Yes, my Lord.
So where are we on this matter?
My Lord, I had an application. I filed an application. I wasn't aware that the matter had come up. I filed an application. The judgment debtor filed an application as well. My application was that the court should direct the judgment debtor to deposit the judgment sum of 7.5 million naira into an interest yielding account. While they sought to oppose the application by filing a counter affidavit. They
Okay.
also have a
So let's address the issue procedurally.
It's all right, my lord.
Okay. So who is addressing the court first?
Lord, on
Their
the
counter
Lord,
was filed.
we, we
Counter was filed out of time, so they have a motion to regularize their counter.
He's in court. Let him speak for himself.
As court pleases, my lord.
all right, my Lord. On the last adjourned date, we actually moved a motion regularizing our counter to their motion, my Lord, and the ruling for the application was for our stay. For our stay was moved today, my Lord.
This is Mr. Nwa Fuzo addressing the court, right?
Yes, my Lord. The matter for today, my Lord, is for ruling on the stay, my Lord.
Okay. Mr. Gbese,
Yes, my lord.
are
We
we all
didn't. We are not opposed to that application for stay. However, we are praying the court that they should pay the judgment sum, deposit it in an interest yielding account. We are not opposed to the application for stay, but we are praying the court to direct that the judgment debtor should deposit the judgment sum into an interest yielding account. We are not opposed to the application for stay. We're only praying the court to direct them to pay the money into an interest yielding account, my lord.
Okay. So I'm going to give a bench ruling, right? So having
My lord.
listened and read all the processes filed, this court distills the following issue, whether a grant of stay of execution is the same thing as the execution of a judgment. Execution of a judgment refers to the process by which a successful litigant enforces the decision of a court to obtain reliefs granted. It is not the act of carrying out or giving effect to the judgment or order of a court. It is a legal procedure by which a successful party, the judgment creditor, enjoys the fruits of their judgment, typically carried out through enforcement mechanisms such as writ of FIFA, attachment of property or guardianship proceedings pursuant to the Sheriffs and Civil Process Act, S6 LFN 2004. For instance, if a court orders a party to pay a sum of money, the execution of that judgment would involve steps taken to recover that money, such as guardianship proceedings or attachment of property. The general principle is that the successful litigant is entitled to the fruits of their judgment, and courts are generally, and I quote, loath to deny a successful litigant from enjoying the fruits of the judgment, as held in Anyanwu versus Okorafor. While a grant of stay of execution is a suspensory order by a court that temporarily halts, frees, suspends, or postpones the enforcement of the judgment or order, usually pending the determination of appeal. Its primary purpose is to preserve the rest, that is the subject matter of the litigation, to ensure that the successful appeal is not rendered nugatory. It prevents successful party from immediately enjoying the fruits of their judgment, usually pending an appeal or the fulfillment of certain conditions. See the Supreme Court case of Ola Bumi and Oyewile. Citations provided, which clarified that, and I quote, an injunction or a stay of execution merely suspends the rights of the successful party until the appeal is decided. Also, as held by the Supreme Court in Vaswani and Savalak, and Okoronkwo and Cognitio Services Ltd, citations are provided, a stay of execution does not nullify the judgment. It merely suspends its enforcement to maintain the status quo pending appeal. In essence, while execution is the active enforcement of a judgment, a stay of execution is the judicial suspension of that enforcement. The court noted that on the 6th day of February 2026, the judgment debtor filed an application seeking for a stay of execution of the judgment delivered on the 7th day of January 2026, pending the hearing of the appeal at the Court of Appeal, and also an injunction restraining the judgment creditor from taking steps towards enforcing the judgment. The judgment debtor submitted that in granting a stay of execution, the court must take into consideration the competing interests of the rights of both parties to justice and equity. He emphasized that the purpose of the stay of execution was to preserve the rest as it sustains the proceedings at the appellate court. He submitted further that the grounds of appeal were meritorious and it would be undesirous for the court to proceed with the case when a notice of appeal has been filed. In response, the judgment creditor filed a motion on notice seeking an order directing the judgment debtor to pay the judgment sum of 7.5 million naira into an interest yielding account of the Chief Registrar NICN pending the outcome of the appeal. The judgment debtor again filed a counter affidavit on the 2nd day of March 2026 and averred that the interest expected to accrue upon deposit of the judgment sum in the CR Chief Registrar NICN account had already been taken care of in the court judgment, that all sums awarded should be paid within 30 days from the date of judgment, failing which simple interest of 10% shall apply. The judgment debtor's bone of contention was that payment of the judgment sum into the Chief Registrar's NICN account would amount to an execution of the judgment despite the pendency of the appeal at the Court of Appeal. The grant of stay of execution is not a right, but an equitable and a discretionary remedy. Courts exercise this discretion judicially and judiciously, meaning according to the rules of reason and justice, not private opinion or humor, as established in Pesas Multidynamics Ltd and Access Bank 2022, and reiterated in AG of the Federation and Adesanya and Josiah Cornelius and Ezenwa. Citations are all provided. Now, having distinguished between the execution of a judgment and the stay of execution, however, the core legal issue requiring determination in this matter is whether ordering the judgment debtor to pay the judgment sum of 7.5 million into an interest yielding account in the name of the Chief Registrar of the NICN as a condition for stay translates to an execution of the judgment. The judgment debtor's contention that such an order amounts to execution is legally flawed and untenable under the Nigerian jurisprudence for the following reasons. One, preservation of the rest in custodial leges. An order directing the payment of a judgment sum into court or into an interest yielding account in the name of the Chief Registrar does not constitute execution. Execution involves releasing the fruits of the judgment directly to the judgment creditor. Conversely, paying the money into court places the funds in custodial leges, that is the custody of the law. The judgment creditor cannot access or utilize the funds until the appeal is determined. The rest is merely preserved to ensure that whoever succeeds at the Court of Appeal will find the judgment debt intact and secured. Secondly, the National Industrial Court Civil Procedure Rules 2017 explicitly empowers this court to grant a conditional stay, specifically Order 64, Rule 4, Rule 14, Sub 3 of the NICN rule provides, and I quote, the court may make or refuse an order for a stay of execution or stay of proceeding and may direct that the judgment sum be deposited in an interest yielding account in the name of the Chief Registrar of the court pending the hearing and determination of the appeal. The court's power to impose such a condition is an exercise of its statutory and discretionary powers to do justice to both parties. Thirdly, this court is also bound to balance the competing interests of the parties as established by the Supreme Court of Nigeria in Kigo and Holman, and also Ndum and Unipetrol, where it was held that the court must balance the right of the judgment debtor to appeal against the right of the judgment creditor to enjoy the fruits of the judgment. By ordering the deposit of the judgment sum into court, the judgment debtor is protected from the risk of the judgment creditor being unable to refund the money if the appeal succeeds. The judgment creditor is also protected against the judgment debtor dissipating assets during the pendency of the appeal. In the second stance, the judgment debtor's argument is dismissed. An order for a conditional stay of execution requiring the payment of the judgment sum into account of the Chief Registrar of the NICN is a valid, protective, and a preservation order. It does not amount to an execution of the order of the judgment, I so hold. The motion on notice filed by the judgment creditor is meritorious and is granted as prayed. The judgment debtor is hereby ordered to pay the judgment sum of 7.5 million naira into the Chief Registrar's NIC account pending the determination of the appeal. The ruling is entered.
I'm most grateful, my lord. My lord, we shall be asking for cost. We ask for cost of 200,000 naira.
The court makes no orders as to cost.
As court pleases. Most grateful, my lord.
The ruling on the stay of execution.
My lord, we moved an application on the last adjourned date on a stay of execution, to which ruling was reserved for today, my lord. We would want to have my lord ruling on the said application, my lord.
Pardon?
We moved an
Talk louder.
application for a motion for stay of execution, my lord,
Mm-hmm.
to which ruling was reserved for today, my lord.
Yes, this ruling has taken care of both issues. Has taken care of the two issues.
Most grateful, my lord.
Yes.
That's the position. That's the position, sir.
Let's go, please.
All right. Registrar,
Yes, my lord.
please, you can leave the meeting now. Khadijat,
Yes, my lord.
call the next case.
NICN/LA/56M/2026 between Jim Marine Latari and Wall Strand Aviation. I'm sorry, my lord. And Wall Strand Support Management Limited.
May it please the court. Please see Ethan and Mrs. Humbly announce my parents for the judgment creditor applicant.
Yes. This weekend, I want to see your face. Judgment creditor.
Yes. Oh, my lord. Apologies, I thought you heard me. Respectfully, sir, CC Ethan and Mrs. I humbly announce my parents for the judgment creditor.
Okay.
Respectfully, sir. My name is today. My humble appearance is for the judgment debtor applicant. With me, sir, is O.B. Ademuji.
OP.
Ademuji.
Can you spell that?
A-D-E-M-I-J. Sir. A-D-E-M-I-J-U, sir.
Okay. A-D-E-M-I-J-U. Can you
Yes,
spell
sir.
your own surname too? Your own surname.
U-D-E-H, sir. U-D-E-H.
All right. All right.
My lord, the matter was adjourned today for ruling of our application, sir.
Respectfully, sir, on the part of the judgment creditor, we have two applications. The first application is our expert
Now, can you take the
application.
microphone, the phone closer to you? I can't really hear you. Can you take your device closer to you?
I can hear you, my lord.
Yes, I cannot hear you.
My lord, can you hear me now?
Okay, a little better.
Okay, my lord, apologies. My lord, please, can you hear me now? Is it audible?
Yes, I can hear. Yes, it's better now. It's better now.
Okay, as the court pleases. I say, my lord, respectfully, before the court, we have pending applications on the part of the judgment creditor. The first is a motion ex parte, dated and filed on the 9th of July, 2016.
The first one, which one?
We have a motion ex parte, sir,
Okay.
filed on the 9th of July, 2026, sir.
Okay.
We have a motion to regularize our counter affidavit to the judgment debtor's application for stay. We have a motion, my lord, for regularization. I want to identify my application, sir.
Yes.
The second
I have
application
two
is our
now.
motion filed on the 15th of July to regularize our counter affidavit in response to the motion for stay of the judgment debtor.
Hold on,
Then
hold on.
we have a notice of preliminary objection dated and filed on the 15th of July.
Yes.
We have the counter affidavit in response to the judgment debtor's application for stay. Our counter affidavit, sir, is filed on the 15th of July, 2026,
Yes.
sir. In order of preference, sir, we respectfully urge that we move our motion ex parte, and after which we move our notice of preliminary objection challenging jurisdiction of the court to entertain the motion to be moved by the judgment debtor. That's our humble application, sir.
Okay. Let me hear from Mr. Today.
Yes, sir. As the court pleases. My lord, sir, in the last adjourned date, the judgment debtor applicant, sir, moved his application for motion for stay of execution, sir. And counsel argued and adopted same and urged the court to give decision in his favor. Your lordship adjourned to today for ruling on the application. Sir, that's notwithstanding, sir. The judgment debtor applicant also filed a counter affidavit, sir, to their notice of preliminary objection.
Hold on,
My
hold
lord,
on, hold on. Hold on, take it easy. Repeat yourself one more time. Take the device closer to you, if it's possible.
as the court pleases, my lord.
Yes.
My lord, I said that in the last adjourned date, sir, that the counsel for the judgment debtor applicant moved and adopted his application, his motion on notice for stay of execution, sir. Sir, we argued and adopted our application and urged your lordship to give judgment, to give decision in our favor. My lord adjourned to today for ruling on our application for stay of execution, sir.
Okay.
Yeah, as the court pleases.
Miss Ikedna. Hello.
Respectfully, sir, we as at the last adjourned date, although I was late in court and I sincerely apologize for that, sir, we're not aware that they did move their motion for stay and my lord adjourned for ruling. We were not aware that that took place on the last adjourned date. But nonetheless, sir, respectfully, although we formally filed a counter affidavit in response to the said application that I've just been notified that was moved before the court, but we have a notice of preliminary objection challenging the jurisdiction of the court to entertain the said application, sir. And then we also have a motion ex parte. So I don't know how my lordship will respectfully want to approach it. First is a motion ex parte, which we ought not to serve on the judgment debtor, properly filed before the court and right for hearing. And I did intimate the court at the last adjourned day that I had such motion. And also is a pending preliminary objection that has also been filed and served upon the judgment debtor. Whereas the asserted response or notice of preliminary objection has not been served on us. So as a date, our notice of preliminary objection is right for hearing, as it has been properly filed and served upon the judgment debtor. And then we have our formal affidavit, counter affidavit. So I don't know if my lordship will want to see that as arresting the order of the court because we were not aware that such motion has already even been moved.
Your Lordship, sir. Your Lordship, we
Yes.
oppose the submission of learned counsel to the judgment creditor, sir. My Lord, sir, in our counter affidavit to their notice of preliminary objection, my Lord, sir, their application, we served them on the 13th of May, 2026, sir. The motion on notice, sir. My Lord, we served them as far back as 13th of May, 2026. My Lord, on the 9th of July, 2026, my Lord, I personally was in court. And
Yes.
I was informed that the date was taken at the instance of counsel. So, my Lord, it is obvious that they waived their right to respond to our counter. My Lord, equity is the vigilant and not the indolent. My Lord, they slept over their rights to respond. My Lord, we served them over a month ago. On the 9th of July, 2026, my Lord, I was in court. And my Lord, it was at the instant, the date was taken at the instance of counsel. My Lord, the counsel on the other side was not represented. We moved our application, sir. We adopted, we argued same. And your Lordship adjourned to today, 28th of July, 2026, for ruling. My Lord, sir, we believe that in the order of priority that your Lordship parties need to the ruling of the court, that the business of today, sir, is for the ruling of the court with respect to our application for motion for stay, that the counsel on the other side failed to respond within time and did not argue or adopted their counter affidavit to our motion on notice. My Lord, our application, my Lord, the case is already a fait accompli, sir, which same we argued on our application. And Lord, what the counsel is trying to arrest the ruling of the court. My Lord, the counsel cannot be a clause in the ruling of progress. Sir, we urge your Lordship, sir, to go ahead with it and deliver the ruling on motion for stay of execution pending the hearing of other applications. Meanwhile, sir, the notice of preliminary objection has already been taken over by event because the grounds of the application is for our motion on notice for execution to be struck out, and that your Lordship does not have jurisdiction to entertain same. My Lord, on the basis of fait accompli, we have submitted our argument. The case has been heard. Your Lordship has adjourned to today for ruling. My Lord, we urge your Lordship to decide the business of today on the ruling of our application, sir. That's our humble prayer, sir.
Can I use your phone? You know mine is bad, so respectfully, sir, by way of response, my Lord, as
Hold
at
on,
the
hold on.
last time,
Just a minute. Hold on.
as the court pleases.
Yes, you can. Yes.
Yes, my Lord, the court is a court of record. As at the adjournment before the last adjournment, I did inform the court that they had filed a motion for stay, but I was not served. I informed the court that I had a motion ex parte for hearing. My Lord would have heard me on that application, but it was not yet before the court. It was on that ground. My Lord wanted to even adjourn this matter for a date in October. I then pleaded with the court on the my motion ex parte to give me a short date. Then my Lord intimated that the court can only accommodate me virtually on the next date, else that application will be moved till after vacation. I saw the discretion of the court. It was on that my plea that the court graciously adjourned the matter for today. My apologies, my Lord, to the last adjourned date to hear the motion ex parte because I had intimated the court I was not served with their motion on notice. Then at the last adjourned date, I was late to court and unknown to me that the said application, what's it called, their own application on motion for stay was taken. My lord, the matter that was to be heard at the last adjourned was my motion ex parte because I had intimated the court, which the court is a court of record, that was not served. Even when I got to court and the matter was already called, I still informed the counsel that I'm not even in receipt of your application. The counsel presently before the court gave an undertaking that I will be furnished with even their further affidavits. It was on that note that I told the counsel that I don't even mind receiving a scanned copy to enable me respond to the said further affidavits. They filed an additional submission to their motion, and I brought it to his attention on the last adjourned date. So, my lord, I didn't even know, neither did he tell me that he moved the application before the court. I would have written to the court explaining the situation. So, my lord, his submission to the court that I slept on my rod, my lord, is unfounded, as that's not the true position of the court. The court is a court of record that I did inform the court that I was not served, and the court adjourned to the last date for the hearing of my motion ex parte. If not, the matter that came up last week would have been after vacation. And my lord, respectfully, the court also has the jurisdiction to entertain applications before it, irrespective of how it may go. And on that note, my lord, in order of importance is our notice of preliminary objection. My lord, jurisdictional application can be brought at any time, even on the day of judgment. And on that one, my lord, we are respectfully urging the courts to allow us move our notice of preliminary objection, my lord, because it's also aid justice in this post-judgment application. And respectfully, my lord, is our motion ex parte that ought not to be brought to the attention of the judgment debtor, which also has been filed and is right for hearing. So, my lord, in summary, we respectfully urge, my lord, for us to move our motion ex parte, to respectfully allow us move our notice of preliminary objection, and respectfully, my lord, we orally apply that my lord should allow us move our counter affidavit for instance of justice and to aid jurisdictional right in this matter, and also for the overall justice of parties, especially the judgment creditor in this suit, and also to aid justice in the matter, sir. We are most obliged.
My lord, sir. My lord, sir.
Yes. Yes.
Counsel for the judgment debtor applicant has a clarification to me, sir. My lord, Lenny Counsel submitted that they were not served with the motion or notice, sir. My lord, sir, this is unfounded because, my lord, we have a proof that the said motion was received and endorsed by a security man, Moses John, on the 13th of May 2020, and even signed. My lord, we have a proof here, sir. Even with the further affidavits, my lord, we serve them. My lord, we serve them the advance copy of our motion that was received. And my lord, the court also served them with their motion notice and our further affidavit in support of our motion. My lord, counsel is flabbergasted by.
Refer to the proof of service. I'm sorry, please. My lord, my lord, what I'm stating, sorry, counsel. We are not fighting. We are trying to aid the court.
Yes,
my
sir.
lord, what I'm stating in fact is that I informed the court as at the date I was in court that I was not served. That I made mention, counsel, sorry, apologies. I made mention that you filed a further affidavit. No, I'm not.
I'm on my feet already, sir. My lord, sir, there is proof, sir, that counsel was served with our motion on notice for stay of execution. My lord, yeah.
Do you have proof for further affidavit that you filed?
My lord, sir, we served them with our further affidavit.
Then point out to the court your proof, because I did inform the court as at that day that I was not served. And I informed the court that I had a motion for ex parte. The court now gave me the date. Just because I came late, I wasn't heard on my motion ex parte. So if you have the proof, no problem. Point it out to the court that I was indeed served. I pointed out to the court I was not.
Counsel, you know what? Hello, network. Hello. 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 Registrar, can you hear me? Hello.
Yes, my lord.
Hello.
As the call, please.
Okay. Okay. Well, we have to be mindful. This is a virtual sitting, so we can't go back and forth for too long before we are all knocked off, because I couldn't even hear what council was saying. So what is going to happen? I'm going to attend to all the applications.
As the court pleases.
I'm going to attend to all the applications. You will send a soft copy of all the applications to the email on the witness box. It's
I've
before
done
you
that, my
there.
lord. My lord, I've sent all my files.
Send all your applications there. I'm going to attend to all the applications. Tomorrow at 3 o'clock, I'll just give a ruling, comprehensive ruling on all the issues. So we
As
don't keep going back and forth.
As
So
the call,
the
please.
court
if you have
please.
any motion to move your motion now, so I can start working on them.
As the court please, my lord, in the light of my lordship kind indulgence, we have a motion to regularize our counter affidavit sought to be moved tomorrow. Our motion for regularization is dated the 15th. Is dated the 15th of July, sir.
Yes.
2026, sir. Is a motion on notice seeking the indulgence of this court, extending the time within which the claimant, the judgment creditor applicant, will file his counter affidavit in response to the judgment debtor's motion for stay execution. And our motion is also craving the indulgence of the court, deeming the already filed and served counter affidavits as separately filed and served. Application is also craving for the indulgence of the court for such further orders that this court may deem fit to grant. Application is supported by an 8 paragraphs affidavit deposed to by the litigation assistant in the firm of the judgment debtor creditor's lawyer. Is also in compliance with the rules attached to written address. My lord, respectfully urge my lord to grant our motion as prayed, sir.
Okay. Mr. Day.
As the call, please. Yes, sir. My lord, sir, we seek your kind indulgence, sir, to move our motion on notice, sir.
Okay, hold on.
Motion on notice was still.
Okay, I wanted you to respond to the motion to regularize. No objection, so we move
No, sir,
ahead.
we are not objecting, sir. We are
Okay,
not.
so hold on also. So order granted as prayed.
As the call, please.
So we've taken care of the first application. Go on to the second one.
As the call, please. My lord, sir, the judgment debtor applicant has a motion on notice, sir.
Yes.
Motion on notice for stay of execution is dated 11th day of May 2026, sir. My lord, counsel is praying for an order staying execution of and or keeping in abeyance the execution of or exercise of rights conferred or deemed to be conferred by the judgment of the National Industrial Court of Nigeria, Lagos Judicial Division, delivered on 8th of May 2026, Quorum Honorable Justice Joyce A. Damachi, in this matter, pending the hearing and determination of the appeal against the state judgment. My lord, the second prayer is an order of injunction restraining the claimant from taking any step or further steps in exercising or enforcing any right purportedly to have been conferred on the claimant by the judgment pending the hearing and determination of the appeal. My lord, we have in support of our application is a 12-paragraph affidavit deposed by Ademola Lawson, the litigation officer of the judgment debtor applicant, sir. My lord, in compliance with the rules of court, we filed a written address and we adopt him as an argument. My lord, sir, the judgment debtor applicant also filed a further affidavit in support of our motion on notice for stay of execution, sir.
Repeat yourself, I didn't get that. Take it easy.
Okay, sir. The judgment debtor applicant also filed a further affidavit, sir, in support of the motion on notice for stay of execution. My lord, the further affidavit is dated 8th day of June, 2026.
Hold on. Judgment debtor also filed a further affidavit in support of the motion on notice for what?
For stay of
For state
execution, sir.
of execution. Okay.
Yeah,
And it
yeah.
dated when?
Sworn at 8th day of June 2026, sir.
Okay.
With exhibit.
Okay.
Attached to it, sir. Exhibit A, sir.
Okay.
My lord, we urge your lordship to grant our application for motion for stay. That was our
Okay.
sir. My lord, sir. Secondly,
Hold on. Yes, go ahead.
as the court pleases. My lord, sir. The judgment debtor applicant also filed a counter affidavit to the
Also filed what?
A counter affidavit, sir, to their notice of preliminary objection.
Okay.
Dated, my lord, our counter affidavit.
So the NPO is dated when?
Our counter affidavit is dated 27th of July, sir, 2026.
Okay.
My lord, we filed a 6-paragraph counter affidavit opposing the notice of preliminary objection for stay, sir.
Okay.
My lord, we also filed a written address in support of our counter affidavit.
Okay.
My lord, sir, in our argument, sir, the judgment creditor slept over his rights, sir. My lord, equity is the vigilant and not the indolent. My lord, sir, they have been served.
You have all that in your written address?
Yes, sir. Yes, sir.
Okay, if it's in your written address, that's fine.
My lord, sir, we adopt same as our argument and we urge your lordship to dismiss the judgment creditor's notice of preliminary objection with substantial cause, sir.
Okay.
We're most grateful, sir.
Okay.
My lord, may I proceed?
Yes, go ahead then.
As a court, please. My lord, in response is a counter affidavit of 13 paragraphs, or 15 paragraphs, my lord, deposed to by the litigation assistant in the law firm of the Judgment Debtors Creditors Counsel. Rely on all the paragraphs of the affidavit. In support is a written address, and we rely on the issues raised, the argument canvassed in support. I respectfully urge my lord to dismiss the motion on notice for stay as urged by the applicants. My lord, by way of adumbration, we want to respectfully point out critical issues that my lordship should respectfully look at. And my lord, those are issues bordering on the express provisions of the rules of this court.
Do you have all that in your address?
Yes, my lord, but just as two paragraphs, my lord, just to adumbrate, my lord, we are stating that
you have a minute.
Yes, my lord, by the express provisions of the Constitution of this country, which provides that every form of appeal from the court of judgment of this court to the higher court ought to be by leave. Also expressly provided under the rules of this court, as highlighted in our written address, states that once the judgment debtor desires to exercise his rights of appeal, he ought to also provide and obtain the leave of the court above. My lord, the grounds of the application of the judgment debtor are one, part of these grounds are that a notice of appeal has been filed. My lord, that is an unfounded ground because before your lordship is no filed notice of appeal. And my lord, assuming that a notice of appeal has also been filed, the rules
Do you
of
have all this in your address?
Yes, my lord, the rules of this court.
Then we can move on. If you have it in your address, we can move on.
Yes,
if you have it in your address.
urge that based on the rules of this court, that the judgment debtor applicant has not obtained the leave of this court, neither has he complied with the provision as relates to compilation of records prior to the bringing of this application. On that note, respectfully urge the court to dismiss the said application with substantial cause. My lord, moving on to our notice of preliminary objection, my lord, respectfully. My lord, our notice of application We are seeking for my Lord to decline jurisdiction to entertain the judgment debtor's application for stay. We are also seeking for an order to strike or at best dismiss the said application for stay. Or in the alternative, if my Lord is minded to grant the said application, my Lord should grant it on the condition that in compliance with the rules, that the judgment sum should be paid into an interest-yielding account in the name of the Chief Registrar of this Honorable Court. We're also praying for such further orders or orders that this Honorable Court may deem to grant. My Lord, the grounds of application are captured on page 2 and 3 of our notice of primary objection. My Lord, in support is our affidavits of 15 paragraphs deposed by the litigation assistant in the law firm of the judgment creditor applicants. In compliance with the rules attached, our written address, and respectfully urge my Lord to grant the said notice of application. My Lord, just to pinpoint, my Lord, by application, we are respectfully seeking for 2 applications. My Lord, the first.
Do you have that? Do you have that in your process?
Yes, my
Then
Lord.
we can move forward. This is a virtual sitting. We don't have time for that before the network knocks us off.
Respectfully urge my Lord to admit and grant the application sought, either in the first instance or in the alternative. My Lord, we also have our motion ex parte of, we have a motion ex parte praying the court.
Dated when?
My Lord, is dated the 9th, it's filed on, dated the 8th, filed on the 9th of July. My Lord, is an application for garnishee application to recover the judgment sums. We have 6 orders on the face of our motion for an order of garnishee against the listed parties on the face of the application, and also for such further orders. Our grounds are captured on page 2 of the said application. The grounds of the said application are also on page 3 of the motion ex parte. In compliance with the rules of this court is our affidavit and support. In compliance with the Sheriff and Civil Process Act is deposed by my humble self. Is an affidavit of 19 paragraphs. In compliance with it is attached, there's an attached one exhibit to the application, which is judgment of this court, a copy of the CTC of this court. And in compliance with the rules of this court is attached the written address. My Lord, we respectfully urge my Lord to admit the said application and grant him. We are most obliged, sir.
Okay. Registrar. Registrar. Hello. Registrar.
Yes, my Lord.
Okay. Do you have virtual sitting tomorrow?
No, my Lord.
Okay,
No,
schedule this
yes.
matter.
My Lord, you schedule it for 3 tomorrow that for ruling. That's
Okay.
for ruling.
Do you have any other matter?
For tomorrow.
For tomorrow?
No, my Lord. No,
Okay.
my Lord.
So the case is adjourned for 3 o'clock tomorrow.
As the court, my Lord, we are most, my Lord, respectfully, just to bring to the attention of the court, we've moved the application of both. But my Lord, let's also put on record that even the counter affidavit in support against my notice of primary objection was not even served on us. But however, not challenging the motion which we go to, but let it be on record, my Lord, that we were not served with the counter affidavit to the notice of primary objection.
My Lord, that's sir. My Lord, they were served. My Lord, they were served yesterday by the bailiff of the court. My Lord, counsel cannot come and be saying what is not the position. My Lord, they were served on record. They were served. Counsel cannot come and be misleading the court.
So case adjourned to 3 p.m. Tomorrow is the 29th.
Yes, my Lord.
29 July 2026.
As a
We are
couple.
most,
Ruling.
we are most grateful, sir. My lord, I
Khadija,
forwarded my processes to the email.
please re-forward everything.
Okay,
Re-forward everything.
as a
Because
couple.
the secretary has not notified me that anything was there. So re-forward everything immediately. Both Ms. Today and Miss Ikenna.
As a
Case
couple.
adjourned to tomorrow, 3 p.m.
As a
As a
couple.
couple, please. We are most
All right.
grateful.
Okay. Khadijat, you can all leave the
Yes,
meeting,
my
please.
lord. Yes, my
Which
lord.
other matter is there?
Shabel and tell you so. My lord.
No, hold on. Hmm?
My lord, should I go ahead to call the case?
You shall call the case.
Yes, my lord. NICN/LA/196/2025 between Mr. Chabel Antonius and Telison Limited.
Who is in court? Parties?
My lord.
The claimant in court?
My lord, parties are absent.
Okay. Appearances? Appearances?
With due respect to my lord, MJ Bashola.
Yes.
MJ Luashola.
And you have
Well,
four?
appearing with me is IF me for the claimant, my lord.
Registrant?
Yes,
Okay.
my lord.
Okay. Is the defendant represented in court?
Very well, my lord.
Respectfully, my lord. My lord, be pleased.
Go ahead.
My name is Louis Okunbowa. Okunbowa is spelled Okungbowa. Appearing with me, CN Emoji. Emoji is spelled MORVI. We appear for the defendant, man.
My lord, the matter is for reported statements. We have complied with the order of my lord by effecting the service of the hearing notice on the defendant. That's why they are in court. Lord, as regards the last adjourned date, I did inform my lord that settlement has broken down between parties because the defendants refused to do the needful according to our claim. I did inform my lord that they have paid the sum of the $8,000 they own the defendants, but as regards the legal fee and the damages fee, have not been trashed out. So during the course of the week, we received a proposal from the defendants, and they proposed the sum of 2 million as the final payment for both legal fee and the damages fee, of which we told them that our clients
Hold on,
cannot.
hold on. I'm writing.
As
Hold on, cancel. I'm writing.
God.
So you got a proposal
From
of 2
the
million as final
defendants.
payment?
Yes. They
Okay.
proposed 2 million as final payment for both legal and damages fee.
Hmm. So have you accepted
No,
that?
my lord. We told them that our clients cannot accept that proposal, that the legal fee is not negotiable, even if we are going to negotiate the damages fee. And we remind them of their terms of settlement they made, of which same is already before the court, that they told us that in case we go to court, that any expenses incurred, they will be the one to finance it. We keep on reminding them about that terms of settlement they made before we come to court. So if at all they are negotiating on the damages fee, we told them that the legal fee of 4.5 million that we spent, of which they didn't counter it, they didn't file anything to counter against it, that one is not negotiable, that they need to pay it. As regards the damages fee, we can sit down on the round table to know the amount they are going to pay. My lord, that's the stage we are.
So the terms had 4.5 million for litigation. Is that what you're saying? Is it 4 million or 4.5? What did you say?
4.5 million, my
Is it
lord.
4 million or 4.5 million? Okay.
4.5 million. Same
Okay,
was duly
I got that.
exhibited in our claim before the court. We have it
All right.
exhibited before the court.
Okay. Mr. Luis? Is Mr. Luis there?
Yes, my lord. Very well, my
Okay.
lord.
Yes.
First of all, I want to appreciate the court for the indulgence granted to us on the 13th of May
I can't
when
see
we,
your face.
my lord. Okay, I said first of
I
all,
cannot see you. Are you in court? I
my
cannot
camera
see you.
is,
Are you in court?
I'm in court, my lord.
The
Okay,
person, the counsel I can see is somebody who has a earpiece. Okay.
yes, my lord, I have earpiece
And
on myself.
tell your colleague to take out his ear. Oh, okay. All right.
Okay,
Okay, go ahead
can my
then.
lord see as the court pleases? So I said on the
Yes,
13th,
I can see you now. Good.
as the court pleases. I said on the 13th of May, I'm appreciating the court for the indulgence granted to us when we took an undertaking to ensure that the $8,000 will be paid before close of work of 14. That we were able to achieve. And then subsequently, I have reached out to the Claimants Council and I did reminded him of a conversation we had the moment we served us with the court processes. And at that time, the conversation was to the effect that if we are able to pay the $8,000, parties would waive whatever other extra claims that was contained in the process. But then I then made a promise that even though the 1 million naira that we were offering at the time was not accepted, and that the court has also given us hints to try our best to see what our clients can do by adding something. Indeed, we did try. Presently, our clients are going through a lot of stress, one or two matters here and there, contract issues, money being owed, and all of that. So despite all of this, we still were able to increase the 1 million to 2 million naira. And I sent a draft of a terms of settlement to claimant counsel, reminded him of the fact that he had promised that we would waive all of these other claims. But anyway, he said it was unacceptable to his client. So that's why we are here. And as it appears, if this state settlement has broken down, I don't think there's any other thing that we can do going forward. That is the position, my lord.
Okay.
We don't want to belabor the court of the rigors of going through trials, writing judgments, and all of that. We were hoping we'll be able to resolve this without much rancor. But this is where we are, my lord.
Okay. Miss Oluwashola.
Yes, my lord.
So what do you have to say?
No, I can't hear that. That's okay. My lord, I'm not hearing you again.
Hello, registrar. Okay.
I'm hearing you now, my lord.
Claimant counsel, you are about to address the court.
Very well, my lord.
Okay, go
Oh,
ahead
the
quickly.
position that the defense counsel was raising on that, we said if they were able to pay the $8,000 is unknown to us. We never said that to him from day one. What we keep on reminding them is that they made a terms of settlement with us. If it was really about the $8,000, we wouldn't have bothered coming to court. We wouldn't have bothered coming to court if they didn't make that terms of settlement with us that they are going to finance any expenses we made. We, based on our premise of coming to court on that terms of settlement, and we assure our clients that with this, we'll be able to recover all the finances that he spent back due to the fact that both parties enter into it, not under duress. They are the ones that enter into the agreement on their own volition. So now going back on the agreement that they have entered, it's a little bit surprising to us. So them coming up with 2 million naira is not it at all. If they can come up with the legal fee, then we can negotiate on the damages. Our client will be okay with that. That's our submission, my lord.
Okay.
As copy.
Since discussions have settled down, then we'll go to trial.
Very well, my lord.
As a court,
We'll go to trial. So Kadida, give us a date for trial quickly.
As copy.
Registrar, can you hear us? Registrar.
Yes, my lord.
Okay, good. So give us a date quickly for trial.
My Lord, 12th November.
Is it convenient?
My Lord, it's not convenient, my Lord. It's not convenient.
Okay. Well, you shall give us another date quickly.
17th November.
It's convenient.
It's convenient.
Okay.
It will be for them to examine our witness. Okay, it will be for them to open their defense. We've already closed our own case.
But, my Lord, we may have to refer the court to the
Yes.
record. Mike, who was around when the trial started, from our records, we are yet to cross-examine their witness, and they are yet to close their case. I wouldn't know. We may have to refer to the court record.
That's the record of the court.
I'm sorry, my Lord. I didn't hear you.
The claimant is yet to be cross-examined.
As the court pleases.
I said the claimant is yet to be cross-examined by the defense counsel.
As the court pleases.
My Lord, this is Ife Snatsi Ume. On the 29th
Yes, the
of
claimant has not. The claimant was asked to step down from the box on the 14th of April.
No, on the 29th of April.
On the 14th of on the 26th of March, the claimant was asked. On the 29th of April, the claimant was in court, represented by Antonio. Then Oluwashola and Ume were in court. Emodi was in court. And the defense counsel informed the court that the parties are still negotiating. We have agreed to pay the $8,000, and I will negotiate to settle the damages and legal costs. Then the claimant counsel said this is not the true position. At the last meeting in Zoom, at the last Zoom meeting on the 8th of April, they agreed to pay the $8,000 and $500,000. Then the claimant counsel informed the court that there was a settlement agreement on the 15th of May with where the parties agreed that the balance of $8,000 would be paid within 2 weeks. Otherwise, the claimant can seek legal and cost borne by the defendant company. The defendants have always the claimant
I'm sorry, my Lord.
Claimant is still in the box. He has not been discharged. So we'll continue from there.
29th of April. Okay, we are bound by the records of the court, though. On the 29th of April, my Lord asked CNMOD if he had questions to ask my clients, the claimants, for cross-examination, and he said no. And then the court adjourned 13th May for defense to open the case.
So that's not correct. I've adjourned this matter. That is not correct. That's not what the records of the court says.
As the court pleases.
The claimant has not been discharged from the box. Emodi was asked to cross-examine, and he said he was not in a position to cross-examine. And we adjourned the matter. That's the record of the court.
As the court pleases.
You can all leave the meeting now.
Okay, my lord.
Adequate, please.
Registrar, give me a minute before you call the next case.
Yes, my lord.
Registrar, call the next matter.
My lord, the next matter is the judgment.
Okay. Between which party?
Timothy, I'm buying on.